over the short adjournment, those instructing me have obtained copies of the explanatory statement for Dublin III, which we were referring to just before lunch. And I don't know if those have been handed up or handed around. Sorry, it's just been given to me.
47.
It's quite lengthy. And I've not even really had a chance to read it, but Mr. Lewis draws my attention to pages 8 and 12. Page 8 is headed Legal Safeguards for Persons Falling Under the Dublin Procedure. And the second bullet point on page 8, the right to appeal against a transfer decision, together with the obligation for the competent authorities to decide whether or not its enforcement should be suspended and to allow the person concerned to remain on the territory pending such a decision are laid down. Moreover, the right to legal assistance and or representation where necessary to linguistic assistance is clarified, the notification process further clarified in order to ensure a more effective right to seek a remedy. And page 12. By the bottom hole punch, the effectiveness of the right to judicial remedy will be increased, in particular by laying down the right to appeal against a transfer decision and the right of not being transferred until a decision on the need to suspend the enforcement of the transfer is taken, providing the person notified of the transfer decision should be granted a reasonable period of time to seek a remedy, laying down the right to legal assistance and or representation. Because that's all the provisions in terms of the legislation that I was proposing to take you to. You've got the upper tribunal determination at tab 8 of the core bundle. We've identified in our skeleton argument the sections of reasoning dealing with this. I don't know if it would be helpful if I took you to them. It's a lengthy and careful determination.
Which tab?
It's tab 8 of the core bundle.
Yes.
And if you look at the introduction at paragraphs 3 and 4, you will see that there were numerous issues in the case, which indeed led to a determination of some 71 pages length.
I think we've all read it.
I beg your pardon, my lord.
We've read the judgment.
Good. Well, I won't take time with it then. You'll be aware that the consideration of Article 27 starts at page 157. I'm going from the numbers in a circle. Article 27 set out at 173. The learned friend's submissions are summarised at 174. The tribunal then looks at the Grand Chamber decision in Geselbash, and it does so at some length.
So, what's the internal page? Because we've got three page numbers.
Yes, there are.
What's the internal page?
Okay, so The beginning of the section dealing with Article 27 is internal page 51. In terms of the page numbers in circles at the bottom, in manuscript it's 157. So the respondent now, applicant then, their submissions are set out at 174, as summarised briefly. The Grand Chamber decision in Gezelbash is looked at in some detail, paragraph 175 onwards. Then the reasoning picks up at paragraph 179, which is internal page 56. The Upper Tribunal makes the point that the Grand Chamber accepted that a transfer decision could be challenged by an individual on the basis that the criteria had been wrongly or incorrectly applied. That's uncontentious. What's contentious is the meaning of transfer decision, as you'll be aware. 180 refers to Mengestab, which is another Grand Chamber decision. There, the Grand Chamber accepted that the remedy envisaged by Article 27 applied to allow for a challenge to a transfer decision, even where the requested member state is willing to take charge, even after the time for making a third country request take charge request under Article 21 is expired. And then you have citations from Gezelbash. Moving on to page 58. The decisions in AS and Shiri apply and adopt the same approach, and it's not necessary to deal with them further. Mr. Lewis, for the Secretary of State, submitted that the remedy envisaged by Article 27 didn't apply in this case because there was no transfer decision, and that remains the key issue. A refusal of a take charge request did not result in such a decision. While Mr. Lewis's submission is not without some force, we don't consider it correct. Except on a narrow reading, a transfer decision will result from an application of the criteria for responsibility, whether a result of accepting a take-back request, or indeed, as in Mengestab, a deemed acceptance. Here, as a result on this reading at least, there is no transfer decision, but that narrow reading is not, in our judgment, the correct one. And the Upper Tribunal starts with recital 19, decisions regarding transfers, paragraph 187. At paragraph 188, they make the point that the Grand Chamber has acknowledged the breadth of recital 19 and the judicial remedy envisaged in Article 27. If Mr. Lewis was right, an individual would only be able to challenge the criteria where that will lead to transfer. The Upper Tribunal concluded that they were in no doubt that the Grand Chamber contemplated an individual being able to challenge the correctness in application of the criteria. Whether, I'm picking it up at the end of line 4, whether the effect of the decision led to the individual's transfer to another member state, or as in this case, left him or her in the member state in which he or she currently was present. They adopt a purposive approach on the basis of Milano Friend's submission, that it's likely, were it otherwise, it's likely that those at the top of the hierarchy seeking family reunification would be the individuals most likely to be deprived of any effective remedy. We don't consider that can have been intended by the CJEU. The distinction between the two situations leading to a difference in an individual's ability to challenge the decision taken under Dublin III would, in our judgment, be arbitrary and unwarranted. We reach that conclusion on the basis of Article 27 and the approach of the Grand Chamber to it, and having regard to Article 47, Charter of Fundamental Rights. So that is the key reasoning.
I know that you're going to come to the cases, but are all of the cases positive decision cases? So are any of the cases where there's been a negative decision?
As in a decision not to transfer?
Yes.
No, they're all cases where...
So this was the first case in which this particular issue had arisen?
Do you mean in the CJEU?
No, anywhere.
There's an upper tribunal decision here which briefly touches on Article 27 and says that there is a right under that. That was under the previous president, McCloskey J. The decisions of the CJEU, I think you've got 9 of them in the bundle. They're all concerned with challenges to transfer decisions to transfer.
A positive transfer decision.
Yeah, positive transfer decisions.
Yes, thank you.
So we say that the tribunal came to the wrong conclusion, that it should have started with the language of Article 27 in the context of Article 26, which we say, as you've heard this morning several times, make it quite plain that what Dublin III envisaged was a challenge to a decision to transfer. That whilst the Grand Chamber has indeed been quite plain that Article 27 doesn't limit the arguments that can be raised on such a challenge, probably the clearest reference, I'm going to try and save time by, rather than going to it separately, take Gezelbash from the sections that the upper tribunal cited. So if you turn back to internal page 53, it's paragraph 176 of the tribunal, setting out 35 to 41 of the Grand Chamber decision. So uncontroversial that in interpreting, you've got to look at the wording of the provisions, general scheme, objectives and context, in particular its evolution in connection with the system of which it forms part. At 36, it's apparent from the wording, so they start with the wording, of 27.1, that the legal remedy provided for in that article must be effective and cover questions of both fact and law. Moreover, the drafting of that provision makes no reference to any limitation of the arguments that may be raised by the asylum seeker when availing himself of that remedy. So, no limitation of the arguments, but the context in which they're talking, in which they're speaking, is obvious if you turn over to page 54. Para 38. Furthermore, the scope of the remedy available to an asylum seeker against a decision to transfer him is made clear in recital 19. So it's right to say that they gave significant weight to recital 19, but they did so in the context of a remedy against a decision to transfer him. And I don't want to take you through it at tedious length, but we repeatedly see in the CJEU case law the phrases transfer decision and a decision to transfer him being used interchangeably.
That's true, but you say that a decision regarding transfer means the same as
Yes.
transfer decision or decision to transfer. That's the point.
Yes, yeah. And that the use of a decision regarding transfer in the preamble can't change the plain effect of the words in the substantive articles. You look at the plain words of the articles first. We see this again, internal page 56 of the Tribunal determination. And this is the Grand Chamber's conclusion, set out at paragraph 178 of the Tribunal's reasoning. At 61, the Grand Chamber stated its conclusion as follows. In light of all the foregoing considerations, the answer to the first question is that Article 27.1, read in the light of Recital 19, must be interpreted as meaning that in a situation such as that in the main proceedings, an asylum seeker is entitled to plead in an appeal against a decision to transfer him the incorrect application of one of the criteria. The Upper Tribunal went on to look at the next Grand Chamber decision, which was Gezelbash. Sorry, which was Mengestab. The first one was Gezelbash. My apologies. So they start looking at Mengestab at paragraph 180 at the bottom of page 56. And if we pick it up at 183 on page 57, recognising the breadth of Article 27 in mandating a judicial remedy in which the criteria for responsibility can be challenged, the CJEU added at 58 to 62, and then they're set out. And again, we have reference to not restricting the scope of judicial protection. But
Where are you reading from?
I'm so sorry. I'm reading from paragraph 183 of the Upper Tribunal, internal paragraph numbering from the CJEU decision in Mengestab 58. So next to the bottom hole punch on page 57, if my lords have it. So the restriction of the scope of the judicial protection afforded by the Dublin III Regulation relied on this respect wouldn't be consistent with the objectives set out in Recital 9 of strengthening the protection of applicants for internal protection. At 59, the fact mentioned by the referring court in its second question that the requested member state would be willing to take charge of the person concerned despite the expiry of the time limits. Do you remember we saw that the time limits affect who's responsible? So the situation in Mengestab was that although the time limits had moved on, so the state that had been requested remained willing to accept the transfer. So the CJU says, well, that's not decisive. But it's paragraph 60 that's important at the very bottom of the page. Indeed, as the remedy provided for in Article 27.1 of the Dublin III Regulation can be applied as a matter of principle only in a situation where the requested member state has accepted, either explicitly in accordance with Article 22.1 or implicitly under Article 22.7, that fact cannot in general lead to a limitation of the scope of judicial review. And this is the Grand Chamber, so in my respectful submission it's quite plain from that reasoning that a transfer only takes place when the requested state has agreed, and that's what a transfer decision means.
It seems to me that that passage is very important because the passages in Gezelbash, one could say, well, they were dealing with a positive decision to transfer, so it was natural for them to speak in positive, in terms of a positive decision to transfer.
Yes.
Yeah. But here, they say as a matter of principle, they look at it as a matter of principle. That's the strength of that. That's the best passage you've got.
Yes, it is in the Grand Chamber's reasoning. There are, I mean, it's difficult because of course there hasn't been an application to the CJEU against a non-transfer decision. Yeah. So there hasn't been reason for it to say, and of course, in these circumstances, it's inapplicable. You've just got to look at the reasoning for why they have said it's applicable in the cases before it. But there are a number of obiter comments that make it clear in my respectful submission.
What is the context in which they're making that comment? They're obviously distinguishing something else. previous paragraph is the fact that the requested member state will be willing to take charge, despite the expiration of the time periods, cannot be decisive.
I don't know if it'd be better, I'm sorry, I was trying to save time and I may not have done at all. If we went to Mengestab itself, which you've got at tab 13 of the main authorities bundle. And may it be helpful to look very briefly at the facts, page 911, paragraph 29 of the judgment. So if you pick it up from paragraph 29,
This is under heading the Procedures Directive. Oh, you've
no, I
got
think you might be in the Advocate General's opinion.
court.
Yeah, court, page 911 at the top. So it's under the heading, the dispute in the main proceedings, and the questions referred. So the situation in brief was that Mr. Mengestab had claimed asylum in Germany on the 14th of September and got an initial registration that day, then was issued with a second certificate on the 8th of October 2015. We go over to paragraph 32. On the 19th of August, Germany requested the Italian authorities to take charge, and the Italian authorities didn't reply, paragraph 33. Paragraph 34, the office, that's Germany, rejected the application for asylum, found there were no grounds for prohibiting his removal and ordered his transfer to Italy. He challenged the decision at 35, and at 36 you see that the grounds for his challenge was that responsibility had been transferred back to Germany because the take charge request had been made after the 3-month period provided for in the first subparagraph of Article 21.1. So do you remember we saw that the state that wants to make a take charge request has got 3 months from the date of the lodging of the asylum application to do that. And if the take charge request isn't made in that time, responsibility rests with the state where the asylum seeker is physically present. So Mengestab turned on whether the start date was the 14th of September or the 8th of October. Germany was arguing that the asylum claim hadn't been lodged until the second date. Mr. Mengestab said it had been lodged in the first date. The reasoning starts at paragraph 41 at the bottom of page 913. By its first and second questions, which it's appropriate to examine together, the referring court asked, in essence, whether Article 27.1 of Dublin III must be interpreted as meaning that an applicant for international protection may rely in the context of an action brought against a decision to transfer him on the expiry of a period laid down in Article 21, even if the requested member state is willing to take charge. And that's because Italy wasn't seeking to rely on the 3-month expiry, it remained willing to accept him. And that's the context for the reasoning at paragraph 60. The court's saying it's irrelevant. The remedy only arises if Italy accepts. The Dublin III Regulation can be applied as a matter of principle only in the situation where the requested state has accepted, either explicitly or implicitly. See judgment delivered today in Essence, Slovenia.
Can we just, I want to read the messages.
Absolutely.
So this one. Is this dealing with the argument of the United Kingdom government and European Commission? 1356.
Thir 1356.
No, paragraph 56.
Oh, sorry.
Just trying to understand what they're referring to.
No, I think it's responding to the referring court's reliance on the fact that the requested member state remained willing to take charge, as set out in paragraph 59. So 60 is a response to 59.
So what this is doing is it's saying you can't deprive the applicant of the right to challenge the transfer merely because the requested state is willing to accept. So it was reinforcing, it wasn't narrowing rights, it was enlarging rights. It was saying you still have this right to challenge the transfer.
Well, that's the consequence, but part of the reasoning is that as a matter of principle, the remedy, sorry if I pick it up on the first line of 60, the remedy provided for in Article 27.1 of the Dublin III Regulation can be applied as a matter of principle only in a situation where the requested member state has accepted, either explicitly or implicitly. Why? Because that's the only basis upon which a transfer can take place. If the requested state rejects, you can't transfer. So it's saying you can only make a transfer decision if the request has been accepted. So it can't avail you that the request has been accepted. That's taken as a given. We wouldn't be in Article 27 territory at all if there hadn't been an acceptance.
And an acceptance within Article 22, which is particularly relevant for this case because of the time limit. I mean, so isn't this a case where there wasn't a positive decision to transfer? Because the decision has to take place within the time limit, it says Article 22, and it didn't, so there wasn't one. So I know we said that this wasn't that there was no case involving a negative decision, but this seems to me to be, isn't this reasonably close, or is that simply not right?
No, I mean, there was a transfer decision. I'm so sorry.
That's the point. There was a transfer decision.
Yes.
There was a transfer
Yeah.
decision. He was saying you can't have the transfer because you're precluded, because you waited too long, so you can't transfer
Exactly.
now. That's what he was saying.
Yeah, yes.
And the government, the German government, presumably, sought to get round that by saying, well, you don't want to worry about all that because they're willing to accept.
Exactly.
And what he was saying, presumably the court accepted, was, well, you can't avoid 19. The recital 19 makes it clear that you're supposed to have very wide rights here, and so you can challenge the transfer even in these circumstances. That's the way it was working. So I'm just trying to understand.
Yeah.
It's not actually very easy.
I'm so sorry.
It's not awful. I'm just trying to understand exactly what 60 is getting at. I certainly don't think it's equivalent to a no decision case, a refusal case.
If it helps, it's quite clear. Sorry, I may have gone through it too quickly, and sometimes it doesn't help if I try and speed up. If we go back to the facts at 33 and 34.
I'm so sorry. Can I just stay on 60 for the moment?
Absolutely.
So
34.
the retort to 59 is what they're looking at. This is why the context is so important. What they're looking at is the situation of, on the facts of this case, where there is a transfer. It's only looking at a transfer situation. It's not looking at a refusal situation. It's looking at a transfer situation where it sought to get round the matter by saying, although you were too late, and therefore you are on one footing, you're stuck with it, you can still challenge the transfer. And they're doing it in the context of saying, in the context of a transfer, there has to be an acceptance. I mean, you can only have a transfer if there's been an acceptance. And therefore, the fact that the state is willing to accept is neither here nor there.
Exactly.
Because the whole way it proceeds is on the assumption that that state is willing to either take back or to take charge.
Yes.
So it makes not a jot of difference whether or not they're willing to take, because that's the whole assumption in the case of a transfer. I mean, they're not actually addressing their minds at all to a situation of a refusal. That's the reverse situation from this. So you say, I'm not necessarily saying you're wrong. I'm just trying to test the case. That's all. I'm trying to test how applicable this really is, because I agree with you that at first sight, if you read it quite quickly, yes, it's focusing on the fact of the transfer and not the fact of the acceptance, or you would say, by analogy, the refusal. It's but it's doing that in the context of rebutting an argument, a specific argument saying, yes, but they're still willing to take. So I'm just querying whether you really can extrapolate from this a situation where there's a refusal, because the argument, the specific argument they're seeking to meet, is peculiar to a case where somebody is willing to accept. That's what I'm saying to you.
Yes.
It takes a little time to get there.
Yeah. No. The Grand Chamber could have said, in a case such as this, where somebody's challenging a transfer, it's a given that there'll have been an acceptance, whether it's express or implied, because there can't be a transfer decision unless, yes. Yeah. But it says a little bit more than that. It says the remedy provided for in Article 27.1 can be applied as a matter of principle. The remedy can be applied as a matter of principle, not as a matter of practicality, only in a situation where the requested member state has accepted. And that's because we say Article 27 only gives you a remedy against a decision to transfer. And sorry, just going back to my Lord Justice Hickinbottom's question, which you may have found the answer to anyway, but it's at paragraph 34 that you see the transfer decision. So at 32, the take charge request is made.
So we're going back to paragraph 32.
Sorry, we're just going back very briefly to clarify that. Paragraph 32, the take charge request is made. Paragraph 33, the Italian authorities just didn't reply, so you've got a deemed acceptance by Italy of the transfer of the take charge request. And then at 34, the office, i.e. Germany, found there were no grounds for prohibiting his removal and ordered his transfer to Italy.
All right, I see your point.
Yeah.
I take your point. Would it be fair to say that the point we're now focusing on was not the subject of argument?
So, I'm so sorry, I didn't
Was
quite
it, I see your point about the general statement in 60, but would it be fair to say that the type of situation we are considering, which is a refusal, what happens there, was not the subject of argument?
Yes.
But I take your point about the general. I take your point about
I've
the
got to say
general
that.
statement. I take absolutely
Yeah.
take that.
Yes. I'm very conscious of the time, and I'm trying to curtail my submissions on the lengthy and complex CJEU case law, because the facts of all the cases are really complicated as well, and because of the changes in states, so who didn't reply to a take charge request in time, and what impact that had, and then was there a transfer in that? They're quite complicated, so what I'm going to do is just try and go through the bits that I think are probably most helpful to my case, so I'm sorry that this is going to be partial. Okay. In my respectful submission, it is significant that the Advocate General in both Geselbash and Mengestab was Eleanor Sharpston. And there are, as you would expect, lengthy and detailed analyses from her which lay the ground for the court decisions to the effect that you should give a broad and generous interpretation to the arguments that can be run under Article 27. It shouldn't be limited, it's not focused on breaches of Article 3 and bad conditions. If somebody wants to challenge the criteria, they're entitled to do that. If they want to rely on expiry of time limits, they are entitled to do that. But it's all in the context of challenges to a decision to transfer. So we've included her opinion at tabs 12 and 13 in relation to both Mengestab and Geselbash. Against that background, could I take you to tab 19, which is another Grand Chamber decision, It's the case of Karim. Could we turn in 2 pages to page 190, which is headed opinion? And at AG2, you'll see that she was delivering 2 opinions on the same day, her opinion in Gezelbash and her opinion in Karim. If we turn to AG12, I think it's probably helpful just briefly to look at the facts, and she summarises them very neatly. So, asylum application submitted in Sweden. Checks in Eurodac revealed an earlier application in Slovenia. Sweden asks Slovenia to take responsibility, and Slovenia agrees. The next day, Sweden tells Slovenia it's got further information, and that indicates that Mr. Karim had left the territory of the member states for more than 3 months. That would mean that Slovenia was no longer responsible. But Slovenia confirms it's willing to process Mr. Karim's request for asylum. The Swedish authorities then reject the asylum application and make a transfer decision. So, question 1 at AG20. Raises similar issues to those raised in question 1 in Gezelbash. Question 2, which is AG36, is a substantive interpretation of the criteria. Does 19.2 mean that the regulation shouldn't be applied where the applicant for asylum shows he's left the territory of the member states for at least 3 months? At AG39, the Advocate General starts her reasoning really. It seems to me questions 1 and 2 are necessarily closely linked. Mr. Karim claims that Slovenia's obligations of the responsible member states ceased by virtue of 19.2, since he left the territory of the EU for more than 3 months within the meaning of that provision. We turn over. We don't really need to trouble, I don't think, more than that with the substantive interpretation of Article 19. But could we pick it up at AG41? In the present case, the Swedish authorities informed Slovenia of Mr. Karim's claim that he'd been outside the EU for at least 3 months. The Slovenian authorities maintain their agreement to take responsibility under the Dublin III Regulation. Slovenia is confirming its agreement to be the responsible member state is not a transfer decision. Italicised. Cannot therefore of itself be the subject of an appeal or review by the Swedish courts under Article 27.1. It is, however, conceivable that the probative value and the weight attached by the Swedish authorities to the information that Mr. Karim gave them in deciding to transfer him to Slovenia could be amenable to appeal or review, insofar as it's relevant to whether the Swedish authorities, obviously the transferring authorities, applied the criteria correctly when making the transfer decision itself. So she's there drawing a clear distinction between the acceptance of responsibility, not a transfer decision, and the transfer decision, which is a decision to transfer. I'm going to try and go reasonably quickly, I'm sorry. At tab 17...
Do we get nothing out of the court's judgment? No.
No.
Thank you.
Not particularly, nothing I don't think which helps enormously either way. we could pick up Hassan at tab 17. So at this point we've reached May 2018. I was going to take them through chronologically, but I'm trying to focus on the key ones. Could we pick it up at 42?
What we're looking at now?
Oh, I'm so sorry. Tab 17, CJEU decision in Hassan and Préfet du Pas-de-Calais. Page 4722. I won't take you to the facts of this, but the question at paragraph 39 was whether you could make a transfer decision before the requested state had actually decided whether to accept or reject your take charge or take back request. So what the French had done was just assume their request would be accepted and make a transfer decision. Could I pick up the reasoning at 41? So at 40 they just say, again, we're very familiar with this uncontentious interpretation, look at wording, origin, context, etc. And the reasoning starts at 41. So far as concerns, first of all, the wording of Article 26.1, that provision states that where the requested member state accepts to take charge of or take back an applicant or other person referred to in 18.1c or d, the requesting member state is to notify the person concerned of the decision to transfer him to the member state responsible, and where applicable, the decision not to examine his application. 42. It therefore follows from the actual wording of Article 26.1, Dublin III, and that as Advocate General Mengozzi has also stated in point 35 of his opinion, in practically all of its language versions, that the notification of a transfer decision to the person concerned may take place only if, and therefore after, the requested member state has agreed to the request to take charge or take back. Or where appropriate, where there's no answer, so you have deemed acceptance. And at 43, the wording of Article 26.1 of Dublin III thus makes clear that the EU legislature established a specific procedural order between acceptance of the request to take charge or take back by the requested state and the notification of the transfer decision. It is not a case where there was no decision, but it's absolutely plain from there that a transfer decision is something that is made after there's been an acceptance.
Well, I think you can go this far. I mean, you can say that in the case of a transfer which is based on an acceptance of either a take charge request or a take back request, all these judgments proceed on the basis that you can't challenge the decision of the requested state to accept. Your challenge must be to the decision of the requesting state to transfer. And I think that's where you can go that, I think you want to go that far, that the concentration is on what the requesting state does. That's what they're all talking about. There's no suggestion that you could at any stage before that transfer decision challenge anything, including the decision of the requested state.
Well, I'd say I can certainly go that far. I mean, as you're aware, my submission is that you can go quite a bit further with confidence and say that a transfer decision is something that can only be made after acceptance. You can't have a transfer decision where there's been a rejection.
Well, I was trying to, I'm saying that wasn't intended, my comment wasn't intended to foreshorten your observation. I mean, the point is that all these decisions are concentrating on the decision to transfer by the state at that point, transferring the state.
Yes, I accept that.
That's the point.
Yes.
And whereas what we're doing here is we are concentrating on what
Decision
would be
where
the
there's
requested state.
Yeah. And then the only other bit I'll go to in Hassan is at 46. sorry, I think we've been to 46. Just for your note, 54 as well. And then at 60, we have reference again by the court to the matter of principle reasoning. It's next to letter E on page 4725. Moreover, the court has previously held that as a matter of principle, such an appeal or application for review can take effect only in a situation where the requested member state has accepted that request. And that's specifically looking at Article 27.1. I think we've referred...
On the Article 8 side, which we looked at before, the coincidence, you wouldn't need an Article 8 challenge to the requested state or the requesting state in the case of a transfer, because you plainly have a remedy under Dublin III. So the point doesn't arise. The odd result, if you're right, is that at least you accept in exceptional circumstances, in some circumstances I think at least, your case would be you don't have a right under Dublin III, but you would have a right vis-à-vis the requested state, not the requesting state, to an Article 8 challenge when plainly, and I think you accept that, when plainly Dublin III is supposed to reflect Article 8 rights, at least as regards family rights. So they're not exactly the same type of situation if you're looking at the whole kind of human rights thing overall. That may not necessarily be against you, but I mean it's a factor. There is a disparity between the legal consequences of the two situations.
Yeah, I accept that there may be gaps that Article 8 has to fill, and as I was acknowledging, I think this morning, maybe not quite clearly enough, I mean this court's held in ZT and RSM that there will be circumstances where Dublin III simply doesn't allow a speedy enough process of reuniting family members.
What is the principle of life in that case?
In determining whether Article 8 applies separately. We go to that next. It's in the authorities bundle in the second volume. We've only included RSM because it's the second of the two decisions and it sets out quite extensively the relevant reasoning from Z to T. So tab 41 in the second slimmer authorities bundle. So probably pick it up at the head note. The key reasoning summarised at 2 of the head note on page 5490.
Yes. Do you want us to read that?
If you wouldn't mind. you'll see at the end of that passage ZT Syria applied, and we see where ZT Syria is addressed, starting at paragraph 34 on page 5500. On 2nd of August 2016, this court handed down its judgment in the Calais case ZT Syria. We don't need to go through the facts. We pick it up at 35. Lord Justice Beatson, with whom Lord Justices Morbick and Longmore agreed, gave the main judgment. He held that Dublin III didn't exclude the operation of Article 8 of the Convention. Dublin III and Article 8 operated side by side.
This is para 34.
35, sorry.
Could you, I would actually like you to read the facts, if possible. 34.
Absolutely.
34.
Yes, please.
I don't know how far ahead you're reading, because you don't need to read, in my respectful submission, 36 or 37, because they're all concerned with a slightly different point about Article 17 or 38. Pick it up again at paragraph 39. Lord Justice Beatson also considered whether a person claiming asylum in another state could rely on Article 8 of the Convention in proceedings in this country. I think that's where it becomes relevant to the question my Lord Justice Simon posed. And I wonder if I could ask you, it's quite a lengthy chunk, but to read through to the end of paragraph 41, which sets out the, we would say, 3 key paragraphs for these purposes of the Lord Justice Beatson's judgment.
Is the test, the last sentence in paragraph 95, no effective way of proceeding?
I think test is that and a very compelling case.
Or an exceptional circumstance, but that doesn't actually tell you very much.
No, it doesn't. I think the court's saying, really, I mean, for example, I referred this morning briefly to Lord Justice Peter Jackson's observations in the course of argument. You've got those at the end of 143. There's a risk that by prioritising the case of one child, the position of other needy unaccompanied children is prejudiced. We're looking here at the sort of case that justifies bypassing Dublin III altogether. Okay. So that's one set of circumstances where Article 8 may apply, and it may require, like the example I gave this morning of the Syrian baby case. There may be cases which are so compelling and urgent that it's justified to say, don't wait for France to go through its processes. This mother and child need to be reunited now. We'll accept that.
You can recognise it, but you can't define it.
It's very hard to define. It's fact sensitive. But there's another point which follows on from that, which is that an application can be made in a less compelling case at the end of the Dublin process. So if a take charge request is rejected and France accepts that, doesn't raise any issue about it, and if I'm right that Article 27 doesn't confer a remedy at that point, the normal course would be to tell the French to speed up, get on with making the substantive asylum decision, and then apply for entry clearance, whether under family reunion policies, under the immigration rules if they're applicable. If they're not, under the Secretary of State's general obligation to grant entry clearance where Article 8 requires it.
What happens if the French say we're refusing the asylum claim?
Well, an application can still be made for entry clearance. It's not contingent on that. So yes.
On what basis?
Again, if Article 8 requires it, because we've got to act compatibly with Article 8. I mean, it's
He says he's the brother,
Yeah.
but nobody accepts that.
Yeah.
The French won't accept it, and nor will your client.
No, that may be right, but of course there's a full appeal on the facts in human rights cases to the first-tier tribunal. But what we're talking about here is circumstances that justify not going through the ordinary course of events.
So what was it? So you said, my lord, yes, no effective way of proceeding, and plus something else. There were two
Very exceptional circumstances.
that was very, very limited circumstances. You say, or
Exceptional.
very exceptional.
Second line of Lord Justice Peake's paragraph
Exceptional
95.
circumstances.
I'd just like to... Sorry. Oh, I'm so sorry.
We're looking at a case that Article 8 requires admission to the country,
Yeah.
which is, as general principle, possible, but rare.
Yes.
So is it, I was going to say just, is it the application of that principle?
Yes, because the argument that's really being run against me is that that refusing a take charge request, even if it's done compatibly with the Dublin regulation, if it's wrong in fact, it will engage fundamental rights. But refusing a take charge request is effectively, in substance, the same as refusing an application for entry.
Yeah, no, quite.
Yeah, exactly.
Yes.
Yes. So, I just want to find, sorry, there's somewhere where in RSM, I'm pretty confident, the court set out the test for Article 8 operating in parallel, and I just wanted to make sure that I took you to the precise language. Could I start, because I found it more easily, with the concurring judgment of Lord Justice Singh? He sets out the test at paragraph 173.
So 173.
Yes.
Is there a general principle that when you're interpreting a regulation of the EU, it should be interpreted, if at all possible, in a way that complies with the European Convention on Human Rights and the Charter of Fundamental Freedoms?
Yes. Yes. But I
So isn't it it has to be interpreted so that it's consistent with
Exactly.
Article 8.
yes.
But there's nothing inherently wrong with a scheme that in itself may allow for the possibility of a breach of Article 8, as long as that possibility is dealt with in some other way, which is why this, quite exceptional jurisdiction under Article 8, you submit, as it were, saves the day.
Yes.
Because the scheme cannot result cannot necessarily result in an Article 8 breach.
No. No. That's precisely the point. Yes. Yes. Article 8 exists outside Dublin III to fill any gaps.
Yes.
Yeah.
As it does elsewhere in the immigration system.
Yes, absolutely, and in other areas of law. Yeah. Absolutely. And I'm so sorry, just going back to the test again, so we looked at Lord Justice Singh, and then maybe the end of paragraph 39 of Lady Justice Arden.
So you referred us to Lord Justice Singh, but which paragraph
Sorry.
in Lord Justice Singh's judgment are you referring us to?
173,
173. I just read.
in terms of where Article 8 requires entry clearance to be granted outside Dublin III.
So, do I understand you to be saying this? Assuming everything you said so far is correct, that the upper tribunal here would have been correct in proceeding as it did with adjudicating on this matter, had it properly found that the situation was exceptional and would not otherwise be dealt with under the Dublin III, the exceptional circumstances being the circumstances in which MS found himself in a significantly deteriorating mental condition. If they proceed on that basis and say, well, we think this is an exceptional circumstance, we accept the argument of the Secretary of State that there's no remedy for a refusal of a request, but this being exceptional limited, we could proceed on this basis under Article 8.
Yes, but can I take this slowly? So just before we get there, the other bit of the test is at the end of 39, where there's reference to an especially compelling case.
Okay, we're going back to...
Going back, I was still, sorry, I was trying to answer the original question by reference to different bits of the judgment, because the different bits of the test are cited a different bit. At the end of 39 is also relevant to the Article 8 test. Yep.
We've now got another
Yeah,
criteria.
is this number 3? So you've got so far
I don't
no
want to
effective way of proceeding, that's one.
Yes.
Very exceptional circumstances is 2. Are you adding this as a third one? And especially compelling?
Yes.
I'm not sure how that's different from very exceptional circumstances, but anyway.
Well, it's the weight of the case.
Yeah. I mean, I think the court is emphasising that this is not something. I mean, one cannot but have sympathy generally with the facts of cases where somebody wants to join a sibling, an aunt, an uncle in the UK.
Well, one can't have sympathy. You say that's not the end of the matter.
No, sorry, I said one cannot but have sympathy. Not one cannot have sympathy, one cannot but have sympathy. But it's also really important to bear in mind that we're dealing with a situation where you have large population movements, and there is in ZT Syria the court made the point that there's a real problem with people trafficking, and that being too ready to admit somebody without scrutinising whether the person that they are seeking to join is actually a relative, as claimed, can be quite dangerous in the case of children. I mean, we're all conscious of cases, for example, like cases where children have been admitted without careful checks and have then been really very seriously ill-treated by family members in the UK. So it is important that
Sounds
there
like
is
a jury speech.
well, I'm simply, it's an important point, yeah, because it doesn't all go one way, and
The jury's standing up.
I do have to intervene here because this is not in the grounds of appeal. It's not in the skeleton argument. We're straying a very, very long way away from the arguments on which permission was granted. I haven't dealt with any of this in my skeleton argument. It's completely new. It's also, I have to say, completely wrong. If I were able to address it properly, I'd be able to show why this case law is not relevant at all on this issue. But I'm really troubled by the way in which, in response to difficulties, we're now straying into a very, very new line of argument for which permission has not been granted.
I'm just endeavouring to respond to questions from the court
Well, I
as to
think
when
that is-
Article 8 can...
I think it's fair for Ms. Giannetti to say that the arguments under ground 1 of the Secretary of State don't lead to a situation where there is a human rights deficit, which is all you're already seeking to do.
Yes. And I'll take it.
But I would observe there's a great difference, in fact, between a case where somebody seeks to, as in this case, to, as it were, avoid altogether the processes under Dublin III, just ignore them completely and go straight to the state they want to be in, and then launch, as it were, a human rights challenge there. That's a long way away from a situation where Dublin III itself, on your footing, doesn't provide a remedy.
Yeah.
They're different situations.
I absolutely accept that, and I just, in fairness to my learned friend, I did not want to be seen to be suggesting, in response to questions about the Article 8 deficit, I didn't want to be seen to be suggesting it's quite easy. All they need to do is raise Article 8, and it's easy to get into the UK. Because it's not. I have to accept it's a point against myself that it's quite difficult to rely on Article 8. But where Article 8 requires it, there is a route. So, yes, the Article 8 deficit is remediable. I think that's anyway. And I'm so sorry, I did get rather drawn into what I think can fairly be described as a jury speech, and I withdraw that.
Fine, right. Where do we go from here? You still haven't done with ground 2, of course.
I haven't got to ground 2. I can deal with ground 2 very briefly because...
Have you finished on ground 1?
Yes, I think so. I think most of what I had as submissions are points that we've explored in the course of my trying to take you through the regulation and the case law. So unless there was anything else that you wanted me to address that you'd find helpful on ground 1. I've probably said too many things more than once, so I apologise for that. Ground 2, I can deal with very briefly indeed.
Right, so this is on the assumption you've lost on ground 1.
This is on the assumption we've lost on ground 1, because ground 2, and I think I confess we've probably strayed slightly beyond that in our skeleton argument, but ground 2, as you'll see, we set it out in our skeleton accurately. We go to tab 4, page, sorry about the numbering, it's internal numbering page 27.
Okay.
In a circle it's page 94.
So going back to the judgment.
No, we're not, I'm sorry. Tab 4, it's going back to the appellant's notice.
Okay.
In fact, we pick it up under the grounds of appeal. Tab 4, page 66 in a circle, is our grounds of appeal. And overleaf at page 67, grounds 6 and grounds 7 were the two grounds on which permission was granted by the upper tribunal.
Yes.
So the second ground is even if a transfer decision for the purposes of Article 27 includes the rejection of a take charge request, the process required by Article 27 doesn't mean that the tribunal must decide itself as a matter of preliminary fact whether the relevant Dublin III responsibility criterion is met. So it's really, does Article 27 require fact-finding? I'll just adopt our skeleton in that regard. We say Article 27 doesn't require it. What it does is defer to the domestic legal order. We agree that under Article 27, the domestic court who's conducting the Article 27 appeal or review function should be satisfied that there's a sufficiently solid factual basis for the decision. We accept, of course, that there is a residual power in judicial review. To make findings of fact. We accept that where Article 8 is engaged, in particular, the court's got to decide proportionality for itself. And that when there's a dispute of primary fact, it's certainly possible for the court to resolve that. So whilst maintaining our position that Article 27 does not of itself require fact-finding, we find it difficult really to advance any substantial criticism of the upper tribunal's reasoning in this regard, in particular at paragraph 208 and 209. Where it's been very careful to urge to note that there should be caution only if it's necessary in order to resolve the matter fairly and accurately that the court should really consider admitting oral evidence. So I don't advance any criticism of that.
So is your criticism, is it not criticism, is the ground really one of principle? And that is, it's a matter of principle that the court or tribunal does not have to determine for itself every fact.
Yes.
But where you're concerned with something that is hard-edged, such as is X brother of Y, that may well be an appropriate issue to determine, for the court or tribunal to determine. Maybe less so if, for example, the issue is it in the best interest of the child to go there rather than here, which is really an assessment rather than a finding of primary fact.
Yes. And of course, Article 27, whether we're right about it or whether the respondent's right about it, is not limited to Article 8 cases. It's not limited to cases where... And so, you know, the point of ground 2 is that Article 27 does not require fact-finding. It will be for the tribunal in each individual case under Article 27, the domestic courts, because it's a national remedy. Article 27 requires the different states to provide their own national remedies, and as the Advocate General has said, to do so in accordance with their own domestic systems. So,
are you saying that the Australian tribunal got it wrong?
no, I'm not.
So where are we?
Well, we're not.
What is the criticism?
Yeah,
None.
no, I mean, we've been granted permission to argue that Article 27 does not require findings of fact, and insofar, and it's not very clear that they did, but insofar as the tribunal thought Article 27 made it mandatory that you engage in fact-finding, that would not be right. I'm not sure they did, against myself, but for the sake of clarity. I'm so sorry this has taken longer than I anticipated this afternoon.
These are important points.
No, they are important points.
Those are your signatures on grounds 1 and 2.
Those are my grounds 1 and 2.
Thank you very much indeed. Yes. Ms. Gilroy, can I just say at the outset, I'm afraid we have to rise at 4:15 today because we're in a happy situation of swearing in Lady Justice Simler as a Lady Justice Appeal, and I, for one, certainly have to be there. I'm sure my colleagues want to be there too.
Thank you very much. Well, I will stop at 4:15. My Lords, your Lordships will have seen from the facts that by the time of the hearing before the Upper Tribunal in May 2018, and there is a chronology, a helpful chronology in the core bundle at 102, in case your Lordships have not spent time with it, it had been almost a year since France had requested the United Kingdom to take charge of MS. And in the meantime, there had been 3 unlawful refusals to take charge of him based on disbelieving the relationship. Now, I want to emphasise that there is no challenge before your Lordships to the parts of the Tribunal's judgment which concluded that those 3 decisions were unlawful, nor is it said that there is no scope for judicial review of whether the United Kingdom is acting compatibly with Dublin III or not in this jurisdiction. So that jurisdiction is untouched, as it must be. As my Lord Justice Hickinbottom observed in the course of my learned friend's submissions, this is a decision, these are decisions taken by a public authority in the United Kingdom, and they have to be taken compatibly with the applicable law, and will always be amenable to judicial review here. So the only issue is whether Article 27 governs that process or requires it. And the only reason it came up in this case was because it was the applicant's argument that the tribunal ought to assess for itself whether having quashed the 3 decisions, whether it should assess for itself whether the relationship was established or not, or whether it should be sent back to the Secretary of State to have another go. The applicants argued, applying Article 27 and the case law on decision-making under Article 8 of the European Convention on Human Rights, that the tribunal should decide it for itself. And my learned friend has now said that the tribunal's reasoning on that ground is not under attack anymore. That's ground 2. And so what that means, as far as this appeal is concerned, is that there are now 2 bases on which this appeal is academic. It's academic between the respondent and the appellant, because there is no longer any list between the parties. And it's academic in terms of what would actually happen in an appeal of this kind, because the appellant has accepted that in a case like this, and in this case in particular, the tribunal would be right to assess the issue on the facts. So the question arises, what is the point of deciding ground 1 in this case? Now, I'm going to come on to address the arguments on ground 1, but I do want to make that preliminary point, because there is no question that the that the respondents would have been able to bring the challenge to the lawfulness of these decisions in the UK jurisdiction. Yes.
Can I just try and fit that in
Yes.
with Mr. Giovanetti's submissions? She says that you can only go for a remedy or procedural remedy under Dublin III, utilising, I think she would say, Article 8 of the Convention in 3 circumstances: no effective remedy, exceptional circumstances, and compelling, in especially compelling circumstances. That's what she says. Now, what you seem to be saying is, yes, but there's a third way. There's remedies provided expressly under Dublin III. There are human rights remedies, but there's also ordinary judicial review of the decision of a public authority seeking to apply Dublin III. Is that right? I'm just trying to see where it fits in. So you say outside the 2 categories that Mr. Giovanetti has specified and gone into, there's this third one. And really it's this third one which lies outside those 2, which is applicable in the UK. Is that right? So I don't know if that's true in other countries. We have judicial review.
We have judicial review, and there have been a series of cases in the upper tribunal challenging decisions to apply Dublin III by the Secretary of State. Those judicial reviews have proceeded without question, because the Secretary of State must apply the law compatibly. No one has suggested that there is no right to judicially review the lawfulness of those decisions. And that is important in this case because there were 5 grounds of challenge to the decision of the upper tribunal to apply Dublin III. Permission was refused on those grounds.
But the judicial, I'm sorry to be a bit panicky.
Yes.
I think it's very important to get this, understand context from this. If you're going for ordinary judicial review, that's
Yes.
not under the Human Rights Act, that's not under the Convention, and not under Dublin III, then your attack is basically based on rationality or incorrect procedure. Is that right?
No, you're challenging an error of law because Dublin III is directly applicable in this jurisdiction. You're challenging the failure to act compatibly with Dublin III. The question is whether Dublin III itself requires that remedy, or governs that remedy. No one has suggested that there is not a remedy in domestic law and that it is not, for example, required directly by Article 47 of the Charter, which I will come on to. So there is no challenge before this court to the conclusions of the upper tribunal, which were that the Secretary of State had acted unlawfully under Dublin III. That is the first lengthy part of the judgment. There's no challenge to those conclusions. The challenge is to whether Article 27 requires an effective remedy in decisions to refuse take charge requests as well as to accept them, and therefore whether the scope of that remedy in fact and law dictates a wider approach than ordinary judicial review. That is the nub of why these issues arose in MS and, for example, have not arisen in any of the other cases which have come and are still coming before the upper tribunal, in which the application of Dublin III is routinely assessed. So this is a very narrow issue in terms of its impact in this jurisdiction. We have highlighted this in our skeleton argument. It's a very narrow challenge, and it's become narrower, and in my submission the need for it has become less clear because ground 2 is no longer live, and ground 2 is the only part of the tribunal's decision that actually made a difference. That is why, if we go just to have a look at the tribunal's decision, why they looked at it. Core bundle tab 8.
I understand everything you're saying. I'm trying to fit it in to the context because we'll have to see how they do. I mean, you're not saying once you've got judicial review, what we're concerned with here is the remedy for it. I'm trying to understand how
the scope of the review. So Article 27 says an effective remedy in fact and law, and that is the part that is. It's because of those words that the tribunal looked at Article 27 alongside the domestic case law on precedent fact, Aon Croydon, misbehaving in terms of Article 8 and Karupin, and now that case law has been bundled up in relation to Article 8 in Balajagari, and that is why, which wasn't before the upper tribunal, but in my submission puts the matter beyond doubt in terms of fact-finding in an Article 8 context. So, but that is why the tribunal looked at this issue in this case. Now, that doesn't mean that the issue raised is not of importance across the European Union. And one of the points that we've made, and I'm going to come on to look to the substance of it, because there's lots to be done, but one of the points that we've made as to why a reference should be made is given that it, and therefore, and it can't be made, and that's why we suggest the appeal should be summarily dismissed in this case, is because it may have far wider implications in other jurisdictions where there isn't this ability to judicial review, if there isn't, than it could ever have here. And those implications should be before the court deciding it. Now,
I just want to make sure that I've got this where this fits in. I think I have. You say that it is uncontroversial that the individual could challenge the decisions of the Secretary of State not to accept the take charge request.
Yes.
Under ordinary public law principles.
Which include a proper application of Dublin III. Yes.
Which include
an error of law.
Yes.
Yes.
Yes, on ordinary public law principles, but including that.
Yes.
But on ordinary public law principles, and those are the principles that we happen to have.
Yes.
That would be different in other countries, but here you say that's uncontroversial.
Yes.
And so really the principal ground was actually ground 2.
Yes.
Because that considers how in the exercise of our ordinary public law principles, we should go about determining the issue which can uncontroversially be made. That
is precisely what I'm saying.
And now ground 2 has gone effectively.
Yes.
There's nothing left.
I think so. I'll be very careful here, because obviously this is. I think it's fair to say Mr. Giovannetti did say ordinary judicial review would apply, but we didn't really go into that. So we've been concentrating on the internal remedies
Yes.
and processes under Dublin III and human rights. So we didn't really go into this area here at all, which you're now, as we're putting emphasis on, because you're saying that's how it's dealt with here. But if you are right, why would you ever need to make a separate challenge, that's apart from ordinary judicial review for error of law? Why, in relation to Dublin III, would you ever have to make a human rights challenge? Because on your basis, you'd always just challenge ordinary judicial review principles, error of law or error of process, or whatever it might be.
Well, my lord, the way in which the challenge operates in relation to Dublin III, which of course is a piece of secondary legislation under European Union law and must be applied compatibly with the Charter, including Article 7 of the Charter of Fundamental Rights, which is the equivalent to Article 8, is that you challenge the decision applying all those principles, including those Charter principles. Article 8, in the context of a challenge like that, usually only arises in relation to damages or declarations under the Human Rights Act as a result of unlawful conduct. And that is how it sometimes arises. In this case, although the tribunal looked at the Article 8 case law, what's important is, and we might need to go back and have a look at the judgment, they drew the connection between Article 8 and Article 7. They said Article 7 provides the same protections as Article 8.
Article 27.
No, Article 7 of the Charter.
Oh, sorry.
So when you are examining how to assess this issue of how the of whether the decision was correctly reached and whether the court should look at the matter for itself, you look at the same principles. All those principles all flow together in assessing, and that's the ground 2 issue, how you approach the question of resolving the judicial review.
Well, obviously you're going to have to, in view of the way you're now opening it up, you're going to have to deal with the situation where these 3 criteria that we looked at, no effective way of proceeding, exceptional circumstances, compelling and compelling circumstances, where they fit into this, because somewhere there's a limitation.
Well, in my submission, they don't fit in at all, and this is the point that I made when I rose in the course of my learned friend submissions. The ZT Syria and RSM are all about outside Dublin III. They have absolutely nothing to do with the application of the Dublin III process. That was the whole point of those cases.
Because they didn't follow Dublin III at all.
They didn't follow Dublin III at all. They had good reasons for not doing so, and those were explained. And in fact, it's important to understand about ZT Syria that the court did not find that the tribunal had erred in the conclusion it reached. It left that open in relation to those 4 individuals who were admitted to the UK, because there may well have been exceptional circumstances in those cases. The issue was that the test hadn't been quite high enough. That's why the appeal was allowed in that case. But it was academic by the time it reached that court, so they didn't remit it back to the tribunal. We can come to have a look at ZT Syria in due course if necessary. But the main point about ZT Syria and RSM is that they were cases where there was a problem in the requesting state, France. So the problem was so intense that children were not able to even make an application for asylum within a reasonable time. There were obstacles. That was what the evidence was all about. So they never entered into Dublin III at all. And the issue was then, if they can't enter into the process in the requesting member state under Dublin III, does that leave them stranded with no ability to rely on their Article 8 rights in order to join family members in the UK? And the court found it didn't leave them stranded. There were circumstances where, if you could show that you could not enter into that process in France, in this case, then you could directly approach the Secretary of State and ask to be admitted based on the separate Human Rights Act, Article 8 jurisprudence. And that is where that came in, and that's where that test applies. That test has no application whatsoever in Dublin III. It would amount to importing into those recitals that your lordships were shown this morning, an exceptional circumstances test for the application of Article 7 of the Charter, which has no justification at all. And it also, from a domestic law point of view, one has to remember where the error lies. So the reason that test was set where it was in those cases was because the error that was causing the delay was a problem in the French system. The unlawfulness.
The short point there,
yes,
at the end of the day, is it doesn't help us at all, because that's a case which has nothing to do with Dublin III.
Yes.
Because Dublin III was never attempted to be implemented in a sense. Nobody got anywhere on it, and it was simply, is there a parallel? The question there was, is there a parallel cause of action?
Yes.
Outside that, which would entitle you to say, you must take us.
Yes.
Basically. Okay.
It was an exceptional jurisdiction. That's the way the court looked at it. That because there was this process that was assumed to be functioning, you had to show that it wasn't functioning. That's where all those points about you must use the processes in France, or at least show that you can't use the processes in France, must be especially compelling and so on, would come into it. There's no wider principle laid down about the application of Dublin III once you've tried to use it, as MS had, where France has done everything it could, and the unlawful conduct that you're seeking to challenge is in the UK. It would be quite extraordinary, in my respectful submission, to apply that test to this very different situation, and there is nothing at all in either ZT Syria or RSM which justifies it. And if necessary, if it is an issue that troubles your lordships, I do think that, and I do submit that the respondent should be given the opportunity to deal with it in writing, because it's not pleaded. It's nowhere in this claim. But in any event, I could deal with it orally. But it really doesn't have anything to do with this case. But I can come on now to ground one. But I made those. Sorry, my lord.
I'm still. I think I understand this submission, but you say that the core issue here, which is the lawfulness of the UK's decision not to accept the TCR because of they didn't accept they were brothers. The lawfulness of that could be challenged domestically by conventional public law principles, on conventional public law grounds. It just so happens, I think you say, that will happily comply with Article 27. Just so happens that it will.
Because of Balajigari and everything leading up to it.
Because it, as it were, it just happens to. In European terms, it's a coincidence, but it happens to. The European point as to the scope of Article 27, then, what that scope might be, is academic so far as we're concerned, and will be dependent to a large extent on domestic rights and remedies in different countries throughout Europe, with which you say we shouldn't become involved. That's your submission.
I say that there is an important issue. I don't deny it. On the respondent side, we've never denied it, about Article 27 and its application to refusals. We say it's covered by Gezelbash and Mengestab, and I'll come on to that. But in terms of implications, it has, in the light of the concession on ground 2, none for this type of case, or for this particular case. I don't say there may not be some nuances in other cases, but they should be explored in live cases where those nuances actually arise. But in terms of a case like this, it no longer has any relevance or importance. That's the submission I made.
So really, we're being asked to give a view on the scope of Article 27.
Yes.
Which A, is not relevant for the purposes of this case.
Yes.
For all sorts of reasons. It's now become academic. And B, you say it would be unnecessary and probably unwise for us to do that because these cases are going to depend upon their particular facts.
Yes.
I mean,
Well, and because and this is a point that we've already made about why this is if there is any doubt about this issue, a reference would normally have to be made if it could be. When the CJU considers Article 27, it must consider, and is able to do so in a way that this court cannot, the implications of the various interpretations proposed across the EU.
Are you saying that from your perspective, the extent ambit of Article 27 point is not act clear?
Well,
what is your position? Are you saying it's
well,
clear or it's not clear?
We say that it's covered by Geselbash and Mengestab in the way, for the reasons that I will come to when I go through those judgments, and that once you look at the bits that my learned friend hasn't taken you to, about the questions that were put, the way in which the various parties advanced competing interpretations of Article 27, and the one that was ultimately adopted, which was option 3, which was an all-embracing option, and I will explain in due course how that is really it was the whole the whole pie chart as opposed to a smaller pie chart of rights that were being protected in option 3. Once you look at that, it is very clear where the CJU would go. Now, I was going to take you to the Act Clare jurisprudence, because it may be that the Act Clare jurisprudence places such a high test that even though it is our submission that it is clear where the CJEU would go, I can't satisfy your lordships that it is Act Clare. And I think we would have to have a look at how the court approaches that in order to...
Well, that may be said, but I'm asking you, what is your... Are you saying it is or is not Act Clare?
We are saying that it is clear, but it may not reach the threshold of Act Clare. But we say that it is clear what the CJEU would do. And I don't think I can put it any differently to that. We would need to have a look at that case law. I think there are some indications that if the court is satisfied that it would be pointless to make a reference because it is clear what the court would do, then it shouldn't do so. But
you at least say it's not Act Clare against you.
Well, I certainly say that it is not Act Clare against me. And in my respectful submission, given some of the discourse this morning, and when you look at the bits of the judgments that have not been, that your lordships haven't been taken to, your lordships will see why I say that.
Can I just ask finally this question, if I may? You've explained the 3 different routes for a process challenge, remedies inherent under Dublin III ordinary domestic judicial review and a human rights challenge. I can't remember now, we have all read the Upper Tribunal judgment. I must say I was left with the impression that they had proceeded on the basis that the challenge was being made under Article 27, not under ordinary judicial review principles. I don't remember them making this distinction that you're making now. Am I wrong about that? Did they in fact make it clear they were proceeding under ordinary JR principles?
I think the way this judgment is structured is that they don't, the Article 27 issue does not arise until they come on to look at what they call, what is the expansive role, should they adopt a more expansive role, and this is at 171 of the judgment on this. And that is where they start looking at Article 27. Until that point, and I have to say, I would need to double check that I'm right about that, but my recollection is that until that point, there is no discussion of it being an Article 27 case. It is all about, I mean, and this is as a result of the way that we argued it, so I have some basis for confidence, but it was all about, was it lawful on ordinary principles, public law principles, including Dublin III, human rights, common law, procedural fairness, and so on. And then, what should they do? And when you get on to what should they do, that's when they start looking at the Article 27 issue.
Just just as the relationship between JR and Article 27 in practice,
Yes.
I think you accept that one could think of circumstances that would not be covered by JR, which, to put it another way, that even if some circumstances were covered by JR, that may not be fully covered by Article 27. But do you say that JR will normally do the trick?
Well, my lord, I don't want to go that far.
No.
Because
it does the trick in this case.
It did the trick in this case. I don't want to go further because it wouldn't be right for me to do that, and I might say something that is not correct. But this is what I do say is what we have been saying from the beginning of our submissions in this case and in the skeleton argument, is that there is a problem. There is always a problem about it being academic between the parties, and now that problem or that issue has expanded to include it's academic because it has no consequences for what the tribunal actually did. There's nothing that they actually did wrong.
These weren't points that were advanced on the application of permission to appeal.
Well, the ground two, the point, there are two aspects of the academic argument. On the application for permission to appeal in the tribunal, a general, at that stage, it was the hand down. It was anticipated that the claim would become academic because the Secretary of State had told the tribunal that he was not intending to ask for a stay on any of the remedies. And so, in broad terms, I made the point that there was an issue about it being academic. But I should say that I did not have with me all of the jurisprudence because the application was made orally and we hadn't had advance notice of it at the time. And that is one reason why the tribunal doesn't address it, save to address the issue of indemnification, leave it for this court to decide on the issues that it granted permission to appeal on. There was then the permission application in front of your Lordship, Lord Justice, my Lord Justice Hickinbottom, on the 5 grounds, but it was not possible, and we subsequently checked this to set aside the grant of permission that had already been granted under the rules, and that is why we advanced it in the way that we did in relation to the question of it being academic between the parties. But the point I'm making today is that as a result of my learned friend's submission on ground 2, there is another point. Now, I don't want to be seen to be shying away from arguing our point on Article 27. It is the respondent's case that the Article 27 argument is very strongly in his favour. But it's right that I should raise these issues so that the court is fully appraised of it in deciding how to proceed in a case which concerns the wider application of EU law. Subject to anything your lordships have to say, I would like to move on to Article 27 to looking at some of these issues and case law, because there are some parts of the judgments which your lordships, I think, do need to see. Now, my lord, may I, before I come to them, just make, as quickly as possible, a summary of the arguments that that we make. And the first argument, that there are three arguments in resisting the appeal. The first is that the upper tribunal was plainly correct because the wording of Article 27 is capable of embracing both the interpretation of the respondent, and I accept the interpretation of the Secretary of State. It is a phrase, transfer decision, which is capable of including both a decision to transfer and a decision regarding transfer. But it is the respondent's proposed interpretation accepted by the tribunal that the wider interpretation is the only one which is compatible with the general scheme of the regulation, its objectives, and with fundamental rights, all of which are given significant weight in the interpretation exercise, as was explained and applied in the case of Gezelbash. Now, my learned friend was asked this morning whether there was anything to support her argument that there had been a policy decision to positively exclude decisions to refuse to transfer, and there isn't any. The answer is there isn't, and quite the contrary. When you look at Gezelbash, you can see, and Mengesov, you can see that the policy decisions are all the other way. What my learned friend didn't address was the tribunal's conclusion that there would be an arbitrary and unwarranted distinction between Articles 8 to 11, which are the provisions of Dublin III at the top of the hierarchy which confer fundamental rights, and Articles 12 to 14, which, as your lordships will have noticed, are provisions which are not about respecting fundamental rights on their face. Those are the provisions in which individuals can expect to be returned to states in which they have previously been present in a variety of ways, either with residence permits or by making claims for asylum or being fingerprinted or whatever it is. And so it would be a very odd result if those were the types of cases in respect of which an Article 27 remedy was given by Dublin III, but not Articles 8 to 11. Now, the second argument was on ground 2, and it now, that issue no longer arises. We do say that Article 27, in the reference to appeals on fact and law, does include the ability and requirement of the tribunal in certain cases to consider facts and decide them for themselves. But in this case, that issue no longer arises. And the third argument is that, at best, the Secretary of State's arguments in the face of this case law, which I'm going to take you to now, raise a small doubt as to whether the conclusions of the court in Gezelbash apply equally to refusals of TCRs. But as my Lord Justice Hickinbottom pointed out, it is certainly my case that it cannot possibly be said to be act clear that the Secretary of State's interpretation is right. Now, my Lord, the Secretary of State's interpretation is heavily based on the wording of Articles 26 and 27. And I do just want to hand up the case of Bulmer and Bollinger, which is an old case referred to in one of the cases in the bundle, but we have not included it, which is just on the approach that an English court should take to principles of interpretation in relation to EU law and how it differs from domestic law. Now, Bulmer and Bollinger, the judgment starts at 415. Lord Denning, Master of the Rolls. And what he addresses in the first part of his judgment is when to make a reference that approach has been somewhat qualified in the later case of Samex, but the principles of interpretation are at 425 under the heading, 425C. And my lords, could I just ask you to read down to the bottom of the page and over the page to 426E. I see your lordships are enjoying the language used, but obviously I draw attention to the particular point made about not overemphasising the words. And when we come to look at Gezelbash, you will see, and some of the subsequent cases, how that works in practice. The wording is only one aspect of the interpretation exercise.
That's what Lord Durning said, but is there anything comparable by way of explaining an interpretive approach from Luxembourg itself?
I will check if that is the case. I can't give you an answer straight away, but what I can do is show you what happens in the individual cases, Gezelbash and so on. So could we start with Gezelbash? It's at tab 12. And what you will see in the judgment, just picking up on that approach, at paragraph 35, is that the scope of the appeal provided for in Article 27 must be determined in the light of the wording of the provisions of that regulation, its general scheme, its objectives and its context.
This is 30.
35 in the judgment at 4,000.
Yes.
And your lordships will see, without going into the detail, that the wording, the consideration of the wording, not going into the detail at this point, at 36 to 40, is only one part of it. The court then goes on at 41 to look at the general scheme. That consideration finishes at 44, then at 45, the general thrust of the developments and the objectives of the regulation. And that consideration then goes on to 51, then at 52, the objectives, and then at 53, a consideration of what a restrictive interpretation of the scope of the remedy might do, thwart the attainment of the objectives. and so on. And that pattern, without looking at the clock, going into too much detail, is repeated throughout the cases in your Lordship's bundle. And if I could give you the references, you can see MA, which was a case about the fundamental rights of the child. It's at tab 10, paragraphs 50, making the same point about 50 in the judgment, making the same point about the interpretive approach, and then that exercise is carried out at 51 to 61, and it includes at 57 to 61 the need to interpret the legislation compatibly with fundamental rights. At tab 17, Hassan, at paragraph 40 of the judgment. Looking again at wording, origin, context and objectives. There is comparison of language provisions on wording, one of the aspects of the approach to wording which we are unable to carry out in this court, but that's a slightly different point. But there is that sequence of interpretation continues, and there is a lengthy consideration of all those various parts of the exercise until paragraph 68.
Is that a convenient moment to pause?
I think it is.
So how long do you think tomorrow you're going?
Well, my lord, given that we don't have to deal with round 2, I hope that I can be... I hope that on going through this case law, I can be around an hour and a half. But if I need to go into ZT Syria and RSM, I will need a little bit of extra time, and I need some time to think about that overnight. But I'm obviously aware of the time period that we've been allotted.
Fine. Thank you very much.
I will go as quickly as I can.